Art and land. Hello, I'm Richard Harwood. I'm a barrister at 39 Essex Chambers.
And I'm Clarissa Levi, Art and Heritage Counsel at Wedlake Bell.
And we're absolutely delighted today to have one of my colleagues from Chambers, Dr. David Sawtell, who is a barrister specialising in commercial and property work, including the art parts of that. David's PhD is in the interface between construction law and land law, and he is the co-author of our book on contested heritage, removing art from lands and historic buildings, which David, Catherine Dobson, and myself in Chambers wrote. And remarkably, we have got to what is probably, I think, going to be episode 14 of this podcast series before actually mentioning the contested heritage book. So I think we've been incredibly restrained. But David, welcome to the podcast.
Thank you very much, Richard. It's a pleasure to meet you, Clarissa.
And what we want to talk about today is the relationship between art in terms of works of art and land. Normally, the art market works on selling paintings and sculptures and so on, but are they part of the building, part of the land? And potentially who owns them? So, David, where did we start?
Richard, there's a huge question, and one has been contested all the way back to Justinian and even into the 12 tablets in Roman law. There's a distinction, we've always drawn a distinction between chattels, objects which are personal possessions, and objects which become part and parcel of a land. And we see that arising as a distinction in a number of different scenarios. Typically, it's about houses where they become part of a land. We see it with construction materials where they become part of a land. And with artwork, if you affix a piece of art to a building, so it becomes part and parcel of a building, it's real property. And we've always treated real property different to if it's simply a chattel which you can pass from person to person. And particularly in some of our exciting 19th century cases, we have wonderful legal terms like fee tail or life interest. You have a distinction between those pieces of art which go with the building, the real property, and those pieces of art which stand by themselves, and you can bequest them through your will, you can gift them. But even today, when we look at some of the works of art, such as Old Flow, there's a real contest and dispute as to who actually owns these pieces based upon whether or not they've become part of a land, or whether a 1,500-ton sculpture is in fact a chattel, like a pencil or a mobile phone.
And just to state the obvious, I'd say that from the point of view of the commercial art market, the real difference this makes is you can sell a work of art that's a chattel. And it is extremely bad news for owners of works of art they're trying to sell when they discover that they're unable to sell their work of art because it is not a chattel, it is land.
Absolutely. And some of the most interesting cases are when you have someone trying to sell the land separately from the contents of a house. Probably the classic example for me is Berkeley and Poulet. That was about Hinton House in Somerset. The Lords Poulet owned the house for 500 years, a south wing designed by Inigo Jones. And as part and inside that beautiful property, you had pictures, and out on the lawn, you had a statue, a Greek athlete that weighed half a ton. You had a sundial outside the south wing. And when the 8th Earl decided to put the ancestral estate up for auction as Lot 1, he wanted to sell all of the other parts, the artwork, the paintings, the statue, the sundial, separately, a separate sale. So Lot 1 goes up for sale, someone purchases it, and they think they've purchased the sundial, they think they've purchased the artwork, they think they've purchased this enormous statue. But in fact, they'd all been taken away. And so what you have is going to the Court of Appeal, having to decide whether an enormous statue of a Greek athlete has become part of a land, became part of Lot 1, or whether the Earl could take it away and sell it separately when he agreed to sell the house. And you have these wonderful series of 19th century cases being referred to that make a fine distinction as to whether it's part of the architectural design or not. And so this classic auction case is just one example where you have a dispute over wonderful pieces of art. And we're going back to whether it's held down of nails, held down of its own weight. And unfortunately, we have to treat it all back down into the material world again.
Yeah. I mean, I'm of the vintage where Berkeley and Poulett was, I think, sort of the first case you were told about in land law lectures. And so, David, what are the tests in terms of deciding whether something, whether it's a statue of a Greek athlete or a painting, is actually part of the land?
Well, they say there are three things in life which are certain. That's life, death, and taxes. And unfortunately, I'm going to add a fourth one to that, and that's probably mortgage lending. So a lot of these early cases hinge around whether or not something's become part of a property for purpose of mortgages, where it's become part of a security. And you have lovely cases about spinning jennies and so on and so forth when the property gets mortgaged. You have lots of cases about houses. And then we have a run of cases about artwork, about how it's taxed. And we have a twofold test: degree of annexation to the land, i.e. how firmly down it's fixed, but then the intention behind it. And the first test sounds quite objective, right? If it's really hard cast down, becomes part of a building, then it becomes part of the land. But in fact, immediately there are problems. The classic example is the dry stone wall. Dry stone walls aren't held together by anything at all except gravity, but they're obviously part of the land. So often it then comes back to the test of intention. And this is where the lawyers start to have fun and the experts start to sharpen their pencils, because you are looking at what's supposed to be objective intention, not what the parties intended at the time or even now. But if you look at that piece, you look at that object, is there an intention to become part of the land? And the cases have developed an idea of it being an architectural design. So of artwork, does it perform part of the overall design of a building? If you have, for example, a room that's been designed to be the Elizabethan room, and it has paintings inserted with niches specially designed for Elizabethan paintings. If you were to take them all away and replace them with David Hockney's, then that's really quite different to the overall architectural design. But then you get cases like the Tower Hamlets case of Old Flow, where you have an enormous statue purchased to go and sit outside a particular place. And there are many such examples, 7 of them cast in the 1950s by the sculpture. And we then have an enormous argument as whether there was an intention that this particular sculpture is intended to be part of the land. So immediately it looked like quite a firm test to one that's shot through with subjectivity.
And just to get to sort of the degree of annexation test, there's an element which items need to be fixed for their own security, to stop them falling off the wall, for example. And I remember I was once advising on the status of a really actually quite spectacular painting in the context of potential acceptance in lieu. I was on a site visit to this hall, and I sort of leant forward to see how it was fixed to the wall. And the whole team behind me from the auction house and the owners and so on all sort of immediately moved forward just to make sure I didn't do anything silly like knock the painting off the wall. There's going to be, for a lot of things, a degree of fixing because you don't want somebody nicking it easily enough and so on. So just the way in which you display a painting, that's not necessarily going to tell you an awful lot about whether it's part of the land or not.
I think the classic example is tapestries, which have built up their own body of case law as to the degree to which they've been annexed to the land. And you have some tapestries which we intended to go from building to building. They're not cut to size, they're not designed to be part of any particular room. During the summer, I ended up in Frederiksborg Castle in Copenhagen, and I ended up doing exactly what you were doing, Richard. I was leaning forward into the tapestries, trying to get a peek to see how it was held on. but also seeing whether these tapestries had been designed to fit in that particular room.
They do get chopped up a lot, don't they? Tapestries constantly being chopped up for new different spaces.
And there are a number of such cases where you see a tapestry from an early period, 16th century tapestry, and then someone wants to put it into a separate room. You see, it's cut up, it's cut to size, and you can see evidence of that. Then it's affixed. And at what point do you then say, well, this is a tapestry, it's been cut to size, but it's been so cut, it's actually become part and parcel of this room?
I think increasingly now with tapestries, tendencies rather than actually to pin them to the wall is to have Velcro strips on the back, so that if the house goes up in flames, then the staff can just rip the tapestries off the walls quite quickly without doing any damage to them, and hopefully get them down the staircase and out into the garden before they're all destroyed.
And does that mean that they're chattels that can be sold? Does the fact of trying to save them from fires actually make them vulnerable to...
Well, Richard warned me not to mention dog grates, but I'm going to do it anyway.
No, I wanted you to mention dog grates.
And I knew I'd be able to steer it back to dog grates, because
Let's talk about dog grates. What are dog grates?
you have this concept in land law of objects which are still part and parcel of a land, but which are easily detachable. And often with tapestries, as you say, it could be it's simply hung. It could be it's nailed in with literally thousands of pins. But then you want to restore the tapestry, you have to remove it. Often it goes to specialists. And when you rehang the tapestry, as Richard says, it's often hung with Velcro. Now, does the act of removal and changing the way in which it's attached to Velcro, which is far easier to remove, change the nature of the tapestry? And there's a wonderful case about a dog grate. As we know, fireplaces have particular grates, and an integral part of that is the part at the bottom. And sometimes that's removable in the same way as a key is removable from a lock in a house. And the classic cases typically say, no, a dog grate is part and parcel of the land, even though it's removable, in the same way as a key is part of a house, even though it obviously goes to work with us in the morning and hopefully comes home again. And when you remove a tapestry then, and you restore it in that way, and you look at its fitting, we come back to that drywall situation. In that, we can only go so far with a degree of annexation. We're thrown back onto that second test of the intent. If I have a tapestry which is held up now with Velcro, but what is the objective intent looking at that tapestry? And once again, we're coming to a far more subjective qualitative test than the empirical test the first limb might seem to suggest.
How does that question of intent tend to get sort of analysed?
I think with great difficulty, and by looking at a run of cases, I've noticed in the most recent cases, we have come back down to using extensive expert evidence, not only to look at the degree of annexation, but the ease with which one can remove an object and what the overall position of it would be, which to me divorces it from what the original purpose of the test was, which was, if you're walking down the street and you see this, do you think it's part and parcel of the land, or is it quite obviously separable? And we do end up in the realms of expert evidence talking about the overall architectural design. We see the origins of that case in one involving the estate of a Mr. Gregory, who was from a long line of Gregorys, and he was the tenant for life. And he had, and one of the disputed items in a wonderful property, a manor house in Harloxton in Lincolnshire, was sculptured marble vases in the staircase. Typically, we think of vases as being chattels. They're obviously removable. We can take them away. And the master rolls held actually they did become part and parcel of the staircase. And it didn't matter whether they're cemented in. He said it was strictly and probably part of the architectural design for the hall and the staircase, and put in there as such, as distinguished from mere ornaments, which are put in afterwards. And he said it was comparable, close your ears now, art fans, comparable to the stone of a mill, which is part of a mill itself. There we are. That's not me, that's what the Master of the Rolls said. And you see this test being applied in more recent cases, such as an Old Flow, looking at the overall architectural design and purpose.
Do you think it makes a difference if something has actually been... So, for example, I'm afraid that I have known art advisors, or certainly people from the commercial art world, who travel with chisels and who are very keen to remove works of art from buildings for sale and are of the opinion that this is going to make a difference retrospectively to whether they were chattels or whether they were annexed.
Fortunately, my clients do not travel the world with chisels. It's the concept of whether or not when you remove a piece of art and restore it or put it somewhere else, even for a long period of time, was something that came up in the old flow case. That was a case where statue purchased expressly to improve a particular part of an estate was actually removed from London to go to Yorkshire Sculpture Park. And it sat on loan at the Yorkshire Sculpture Park until then it returned back to London. Now, does it then cease to become part of the land, if it ever became part of the land or not? And we have this hazy area where material, and it could be artistic material, it could be other kinds of material, was either deposited on the land or was taken away on the land. And what happens if it stays away from the land for a long period of time? And it's quite a hazy area and legally uncertain.
I mean, some of the disputes will arise in the Berkeley and Poulet type situation of a property sold and the owner turns up and the purchaser turns up and finds that the seller has sort of not only taken all the light bulbs, but they've removed the statue and the paintings and the chandeliers and various things which they thought they were getting with it, and so on. But there are also, in quite a few of the cases, a dispute between somebody who owns the land and somebody who owns the chattels. And it seems to me that a lot of the Victorian Edwardian cases, how does that dispute come about in terms of who the participants are?
As you say, a lot of these cases are more Victorian cases because since the wonderful Law of Property Act of 1925, we don't have so many estates in land. We just have leasehold, freehold, wonderfully under Section 1. But in the Victorian cases, we are going back down to life interests and the idea as to what went with which part of the inheritance. So the classic case of that was Lee and Taylor, the Luton Hoo estates, where Madame de Falbey was a tenant for life. So she doesn't own the freehold, doesn't own the real property, but has a life interest in the property. And we come back down to our favourite point, tapestries hung over canvas and affixed with tacks, and mouldings fastened to the wall were placed around each piece of tapestry. And these were worth thousands, and I think £7,000 for matter in dispute, which in 1902 is quite a serious sum. And that's one of the reasons, of course, it had to go to the House of Lords. And the idea was the life interests part of the tenant for life interest, did they intend to make a gift of these beautiful tapestries that have been fastened very hard into a building and then quite difficult to remove? Or did they still remain chattels that would then pass with her personal estate that she could grant by will? And it was held that the only purpose of these tapestries was ornamentation or decoration. They had not been affected so much by affixation. Now, you might well say, good result, but again, it seems to clash with the second limb of that test, which is the objective intention of the parties. Because how am I to know if, when I'm sitting down to dinner with Madame de Falbe, whether or not she is the tenant for life there or has the whole freehold interest, without asking a dreadfully rude question at the dining? I certainly can't tell by looking at the tapestries. So we almost make a point of it being an objective test, but then we look at the nature of their proprietary interests, while at the same time that we're drawing a veil over the subjective intention of the parties as being one thing we cannot look at, which is why this area of the law has been criticised for being uncertain.
Well, it's sort of saying, well, you can't do it subjectively in the sense of this is what you had in mind, or the parties can't agree that black is white. And there's the far more recent tax case of Melhuish, I think I pronounced it correctly. Was that the one where the council had got lots of central heating systems, which had installed but had borrowed the money, and the contention for some tax reason was that the central heating systems were still owned by the people who'd provided them rather than owned by the council. And the court said, well, look, they're part of the building. You can't just write a contract saying they're not. But you have to look objectively at the circumstances. And in Lee and Taylor, wasn't one of the judges saying, of course, the argument's recorded in the law report. What if she only had an interest for a year? Would a yearly tenant mean to gift the tapestries to the owner of the freehold?
As I said, three things certain in life, and Meloesian BMI number 3 limited, certainly one of those ones where taxation's played a massive role to play. And there are two ways to approach that case. You can approach it narrowly on the facts. The agreement that these particular items were in fact retained by the vendor was only entered into after they'd been affixed. So it was almost like a retrospective agreement. So that's the simple way to deal with it. But in fact, the far more interesting point to say, we're coming back to, despite what you agree, what is the degree and object of annexation, and what is the objective intent? It doesn't look at what did you subjectively intend to. And you can look at the cases involving industrial machinery from the 19th century, where you'd even put a lovely brass plate on your machinery saying this remains the property of X Limited, and it was held not to be effective because we're not looking at subjective intent. But at the same time, I am allowed to look at the interest in land as to whether or not they're a tenant, a freeholder, and so forth.
There's one aspect to the property case law, which is, I follow the concept of tenants' fixtures, that you may have items which become part of the land, but the tenant is still entitled to remove them at the end of the tenancy. Now, how far does the case law explain that? Because if we're looking at ownership, potentially depends on when you make the determination. It can matter a lot whether it's part of the land, but the tenant can take it away, or it's always the tenant's, it's never part of the land.
Now, most of the leading cases about this are about very boring things, such as industrial carpets and industrial machinery. So there is a far more limited, but far more interesting line of cases about ornamental and domestic fixtures. And the case of Spire and Phillipson is one which I was able to put into the book and really enjoyed. This is where the lessee of a flat installed wonderful antique oak and pine panelling, chimney pieces and fireplaces into their flat. You might fall over very classic things which you'd normally expect to see become part and parcel of the land. And the landlord argued they had become landlord's fixtures who could not be removed by the tenant. But I assume Mr. Justice Luxmore was an art fan and a fan of the lessee, said this general rule fell into well-known exceptions. I have to say his exception was not so well known. He said that in this sort of case, the tenant did not have the object of making a gift of panelling, chimney pieces and fireplaces. And in any case, method of attachment was light. And a court of appeal agreed. And it seemed to create a further exception for tenant ornamental fixtures. And you can see a thin line of cases. I have to say, I wouldn't recommend you try and follow them because they are, as I've possibly suggested or implied, not entirely of keeping with the more modern cases. But you can find cases from the 1850s and onwards where you have this ornamental fixtures and fitting style cases which seem to represent an exception to the normal rule.
This is what I love about our entire legal system. If you're presented with something where there's an obvious right answer, you just jolly well find a way, make up an exception, claim that there is a well-known exception. And it makes a broader point as well about just finding your way through, quite regardless of the more boring examples of chattels, and saying, well, art is a bit special.
And I think that's part of the nature of common law. And I know in earlier podcasts, we've gone back to 16th century. Well, there's a wonderful 16th century case where a cider making vat, the issue was whether or not that became part and parcel of the land. We can see that as one of the seminal cases for the tenant actually improving the land, but being entitled to take it away again. Because when you go into the earlier sort of 14th century cases, it's quite harsh. But when you see the common law developing this idea of tenants' fixtures, this is an offshoot of that. But see, part of the problem with that, Clarissa, though, is you then end up with a sort of barnacle-like development of the common law. It actually becomes then quite difficult to see a way through this thicket of cases, exceptions to the exception. You try and clarify the law with the Wheatstone and Morris twofold tests, but that itself is too broad to affect every single case, particularly when we have the art and heritage cases.
I think the point about judges is that they are trying to do justice in the facts of the case and the circumstances that they find when you've got two or sometimes more competing parties in a legal system which works heavily on precedent. And in this particular field, it's very much common law, it's case law based. But the judges are trying to reach what they think is the result that justice wants, reflects the merits of the case, which does mean, I suppose, put it politely, that a lot of the outcomes are very fact sensitive, but also you get results which you may well struggle to reconcile, both the outcome and the reasoning, because the judge thinks it should go into a particular direction.
And certainly it's something I explored in my PhD thesis when I looked at this interface between chattels, in my case, construction materials, and the land. And what you've just described, it sometimes resonates with legal realism. And so you see academics like Ronald Polston very much trying to give a broadside in favor of legal realism. He says it's absurd to contend, as do those courts and writers who still mouth for doctrine and pretend as a basis for deciding disputes, that something of legal significance has occurred simply because someone has placed an item of personality in a more or less permanent fashion on a tract of land. And what he's trying to say is we've got these decisions, we have these rules, but actually are we just trying to throw a cloak over? They say what the judge is trying to do is saying bad guy loses, in effect. I would very strongly say no, that's not what we're trying to do. But we have a line of doctrine which you can trace back through the 11th, 12th century and back into development as part of civil law, Roman law. But what we now need to try and do is try and form a rationale for that and a way that we can move forward predictably. Otherwise, you're going to end up in cases where it does depend on the mood and temper of a judge, which is not a good way to make decisions, particularly when millions of pounds of tax, sale of land, auction issues arise from it.
And the whole purpose of a court system is, well, the whole, but one of the purposes of the court system is to have a set of rules, which means that people know how issues will be approached, and so will know how to secure what they want to secure or what has actually been agreed and what's not been agreed, without having to go in front of a judge to resolve the dispute.
And preferably not just by approaching with a chisel.
So, bringing us up to date, we've touched on Old Flow. How did that legal dispute arise?
In that wonderful way in which public money is best used, unfortunately, there was a dispute between two local authorities. And it began, I would suggest, with the best of intent. And as I've just been mentioning way through, we have this wonderful statue by Henry Moore, a draped-seated woman. Cast 7 of them in the 1950s. So you see some in Cologne, Brussels, Yale University. And one of them was bought by the London County Council to go in the Stifford estate in Stepney, in what is now the London Borough of Tower Hamlets. And Tower Hamlets wanted to sell it to raise money. And the London Borough of Bromley objected. They said, actually, we are the successor to the London Residency Body, which is the ultimate successor to the London County Council. And so you have to then trace the historic sort of cycle of these local authorities. So it was a tawdry dispute over money and who owned this sculpture. And unfortunately, we end up spending legal fees precisely because a local authority wanted more money to sell it for public good, for public purposes. It was always a controversial statue. When it was put in, the local newspaper commented, "What is this? Is this monstrosity supposed to represent womanhood? Surely there's something wrong with art, capital A art, when it deliberately sets out to portray a malformed, ill-proportioned wench as a woman. What does the statue just off Jamaica Street suggest to the passer-by?" So you have this argument, whether or not 1.5 tons Henry Moore statue is actually part and parcel of the land, or, as I said, like a mobile phone, like a pencil, like anything else, is actually be put in your pocket and taken away. It's not part and parcel of the land. And overall, Mr. Justice Norris held it is its own object. And part of that was it can beautify Stepney, but it could also beautify Cologne or Melbourne. So there was no integral design in this estate. The estate wasn't built part and parcel of this sculpture. And therefore, it was a chattel. And it was something that could be removed. And the same as it had gone and spent half of its life in the Yorkshire Sculpture Park. Now, sitting back, you think that's right. It doesn't matter how big it is. After all, the space shuttle is no less part of real property than my pen, despite how big it is. But if we're coming back to architectural design, and the academic Chris Bevan has criticised it, we are having value judgments about what is art.
And the final case I want to touch on, because we touch on it in the book in a few different aspects, is the statue of Colston, which was the statue of the Bristol slave trader, which was in 2020 pulled down and thrown into the Bristol harbour and finally sort of fished out and so on. Now, a number of different aspects to that, the criminal proceedings, listed building issues, and so on. But one of the points just raised the question of ownership, and it's something which we touch on in the Contested Heritage book. Finally, for the 14 episodes, giving a plug for it. But you want to just sort of explain the ownership and trust issue that you think arises on the Colston statue?
Absolutely. At a very fundamental level, we ask, what is ownership? And whether academically, however we approach it, ownership must suggest some level of control. And one of the issues leading up to how the Colston statue was removed, I don't know if it was chisels or far more force than that, and it ends up in the harbour, was because it was a heavily contentious statue. But no one wanted to stand up and say, I own it, and I want it to stay here. Instead, everyone wanted to step back and say, I don't have the requisite degree of control over it, and therefore I'm able to step forward and take responsibility for it. And that became an issue in the criminal trial, when the issue was criminal damage. The defendants didn't assert it belonged to them, so property belonging to another, that part was paid out. It came up in the defence as to whether or not they honestly believed the owner would agree to it. And they said it's actually being held on trust, being held for the people of Bristol. And no one seemed to challenge the idea as to whether or not the Colston statue was being held in some kind of trust for the people of Bristol. Putting on my black letter law cap and looking at it, I cannot see a trust for this statue that's been granted orally as it's handed over by the corporation that have funded it and gave it to the local authority. I simply cannot see how that works. But there seems to be the legal myth developed that the city corporation cannot do anything with it because they're holding it on some kind of trust. It's been fixed to the land. We know that because when it was pulled down, part of the plinth had to go with it and went into the harbour afterwards. It couldn't be separated from the land. We know the plinth is part of the land as part and parcel of the statue because it has to be a Colston statue plinth. It refers too many times to Colston. It makes too many references to Colston's life. So this part of the land, we should know, applying Elitestone and Morris, who it belongs to. And if there's no trust, then it's the owner of the land. So I make the argument that sometimes we're using ownership, not so much to clarify the law, but to say you can step back into the shadows by not asserting ownership. And therefore something remains there because no one has stepped forward to assert private law control over a particular object, which then makes it more difficult if other parties wish to contest, as a matter of public law, whether or not it should remain.
David, thank you so much for that discussion and that exercise, which has taken us all the way from the Romans to I think I have to describe as behaving badly in the Victorian period, bang up to two recent contentious cases of public art, which show how important all these concepts are. So, David, thank you so much for your time.
Listening to this discussion of case law has been an absolute joy. Thank you so much.
Thank you for listening to the Art and Heritage Law Contested Heritage. Please do follow or subscribe on Apple or Spotify podcasts to enjoy more shows.
We have a new podcast out every fortnight. If you're able, please take the time to rate us and put down a review.
The show is also on the 39 Essex Chambers website, along with podcast series on topics such as artificial intelligence, climate change and planning.